If you've just lost a loved one, you're probably already overwhelmed, and now someone tells you you have to go through probate. One of the first questions that comes to mind is, how long is this going to take? Is it weeks, months, over a year? The truth is, it depends on the type of probate, the estate's complexity, and how smoothly everything is handled. Today on Clear Probate, we're breaking down the Florida probate timeline step by step. By the end of this video, you'll know how long summary administration usually takes, why formal administration is often much longer, the biggest causes of delay, practical ways to keep things moving, and along the way, I'll share real examples of Florida families who went through probate so you know exactly what to expect. Probate isn't just about paperwork, it's about real families waiting for closure. The probate timeline matters because heirs need access to assets. Families may rely on those funds. Creditors have deadlines. They only get a short window to file. Executors have heavy responsibilities. Most aren't professionals. They're family members juggling jobs and grief. Emotional closure is delayed. Families often feel like life can't fully move forward until probate ends. Quick audience question. If you were waiting on an inheritance, would you rather have it faster with less oversight, or slower with more checks and balances? Drop your answer in the comments. Let's start with the faster, more streamlined option, summary administration. This process is designed for smaller or older estates, allowing for a much quicker resolution. Florida allows summary administration if one of two conditions are met. First, if the estate's probate assets are worth $75,000 or less. This value excludes exempt property, like the primary homestead. The second condition is if the person has been deceased for more than 2 years, regardless of the estate's value. Why does that 2-year rule matter so much? Under Florida law, it's a hard cutoff for creditors. After 2 years, their claims are barred. This eliminates the need to formally notify them, a step that significantly shortens the probate timeline. Here's a look at the typical summary timeline. Weeks 1 to 2. A petition is filed listing assets and beneficiaries. Weeks 2 to 6. The court reviews the petition. Months 1 to 3. The court issues an order of summary administration, which legally transfers assets directly to the heirs. So in total, most summary administrations wrap up in a swift 6-12 weeks. Let's look at a mini story. Take Anna in Tampa. Her father left behind $40,000 in a savings account and a car with no debts. Since the value was under $75,000, she qualified. She filed the petition, and the court issued an order she could take directly to the bank. From start to finish, just 9 weeks. That's how fast and efficient probate can be, saving time and stress when an estate qualifies for this expedited path. Now let's shift our focus to formal administration. This is the more comprehensive, court-supervised process designed for larger or more complicated estates, ensuring every legal requirement is met. Formal administration is required if the estate's non-exempt assets exceed $75,000. It's also necessary for disputes among heirs requiring a judge's oversight, or if the estate has numerous creditors or complex assets like a business. This structured process ensures proper management. Here's a look at the step-by-step formal timeline. Weeks 1 to 6. The process begins by filing a petition, and the court appoints a personal representative to manage the estate. Within 30 days, a notice to creditors is published. This starts a strict 90-day window for creditors to file claims. Within 60 days of appointment, the representative must also file a detailed inventory of all estate assets with the court. Months 4 to 9 are spent resolving claims and paying valid debts. This step is crucial before assets can be distributed. Months 6 to 12. With debts cleared, a final accounting is prepared for court approval, then remaining assets are distributed to the heirs. Finally, the court approves a petition for discharge, officially closing the estate. Total time is typically 6 to 12 months, but complex cases can take longer. Let's consider David in Miami. His mother left a $300,000 home and investment accounts, pushing the estate well over the $75,000 threshold. Some debts had to be settled, and he had to coordinate with 3 siblings. While not litigious, their differing opinions required careful negotiation. Because of these factors, the probate process took 11 months before the estate was finally closed. This shows how even without major lawsuits, the necessary steps of formal administration take considerable time. Why do some cases drag on for 18 months or more? Creditor claims creditors have 3 months by law. Heir disputes, fights over wills, property, or distributions. Complex assets, businesses, real estate, or collections require appraisals. Out-of-state property triggers ancillary probate, court backlog. Some Florida counties are faster than others. Executor mistakes, missed deadlines, incomplete filings. Which do you think causes more delays? Family disagreements or missing paperwork? Tell us in the comments. We'll compare answers in a future video. Common questions families ask. Can probate take less than 6 months? Yes, with summary administration. If all heirs agree and no debts exist, does it go faster? Yes, but formal probate still takes 6 to 9 months due to statutory deadlines. Can assets be distributed before the case ends? Sometimes. Partial distributions are allowed with court approval. Does a will shorten probate? Not by much. It clarifies heirs, but statutory creditor periods still apply. What if the will is contested? That can add a year or more. Probate can last 2+ years if litigation is involved. Tips to speed up probate. Organize early, collect documents right after appointment, file before deadlines, don't wait until day 60 for the inventory, communicate with heirs, prevent disputes before they start, hire professionals. Attorneys and appraisers prevent costly errors, pay valid claims quickly, don't let them pile up, keep records. Judges want clear documentation. To see how these timelines play out in the real world, let's look at a few examples. Jane in Orlando handled her aunt's estate. She filed everything on time, hired an appraiser for the house, and kept her siblings updated every step. This transparency prevented family disagreements, a common delay. Probate closed in 7 months, on the faster end of formal administration. Her diligence shows what's possible with an organized approach. Compare that to another family in Jacksonville who delayed filing the notice to creditors. This notice starts a mandatory 90-day creditor period. That alone added 3 extra months to their timeline. Case 1. Summary administration. Sarah's father left $50,000 in a bank account. Because the estate was under the $75,000 threshold with no debts, she filed for summary administration, Florida's simplified probate track. 2 months later, the estate was closed. This is a best-case scenario for a simple, straightforward estate. Case 2. Typical formal probate. Robert's mother left a $200,000 estate. No disputes, but formal probate was required due to its value. The process was smooth because the will was clear and beneficiaries agreed. It took 9 months from start to finish, a very typical timeline for a standard formal probate case. Case 3. Complicated probate. Linda's uncle left property in both Florida and New York. This required a separate court process in New York called ancillary probate. Ancillary probate in New York delayed the Florida case. The total timeline, 20 months. Coordinating between 2 states is complex and adds time. So how long does probate really take in Florida? Summary administration, often 6 to 12 weeks. Formal administration, usually 6 to 12 months. Complex or disputed cases, 18+ months. The timeline depends on preparation, cooperation, and whether disputes arise. If this video helped you, subscribe to Clear Probate and let us know your thoughts in the comments. We read every one. Here's my final question for you. If you were handling probate, what would matter more? Finishing quickly or making sure every detail was double-checked? Share your answer below and we may feature it in a future video.
If this helped bring clarity to your situation, hit that like button and subscribe for more guidance.